All right. Good afternoon and welcome, everyone. Thank you so much for tuning in to today's live event as we'll be going over Seattle's new Freelance Isn't Free law. Feel free if you have any questions, type them in the chat. We'll do our best to get to all of them and any of them. Be sure to check out all of the links down below in our description as well. If you do not know who I am, I'm Jalen Vasquez. I'm the director of Freelancers Hub, Freelancers Union co-working space in Brooklyn. We offer free co-working and various workshops for freelancers to help them bring their business to the next level. Today, we will be joined by Meredith Ruff from the City of Seattle's Office of Labor Standards. But before we bring her on, I would like to welcome our Executive Director, Raphael Espinal, who would like to say a few words just about the law and all of our efforts. All right. How's it going, Raph?
Hey, thank you, Jalen, and good afternoon or good morning to everyone who's joined in. My name is Raphael Espinal, and I'm the Executive Director of the Freelancers Union. And as you may know, we are a national organization doing the work to provide education, advocacy, and resources to the independent workers, no matter which industry you're working in. So it really makes us really happy and proud to host this meeting today for many reasons. One, of course, this is the culmination of our advocacy across the country and ensuring that all freelancers have some sort of recourse and resource if they encounter a non-paying client. And the City of Seattle has been spearheading this effort for a few years now. And it's definitely a place that we value because we know there's a lot of you who are living and working there. So for the first time in the city's and state's history, there is a place you can go without having to go to small claims court, where you'll have a city agency advocating on your behalf. So again, this is work that we're trying to continue to push across the country. We now have the city of LA with a similar law. The city of New York has had this law since 2017. City of Minneapolis got this passed during the pandemic. And just most recently, the governor of Illinois signed a Freelance Isn't Free or Freelance Protection Ordinance in the state of Illinois just a few weeks ago. So again, we're super excited and we're happy to have Meredith from the city of Seattle here to explain to us, how the law works there and who you can reach out to and speak to in case you encounter an issue with a non-paying client. But again, we're always here as a resource. Feel free to reach out to us anytime at freelancersunion.org or more easily at advocacy@freelancersunion.org. Thank you, Jalen, and thank you, Meredith, for putting this together.
Awesome. Thank you so much for joining. But yeah, like Raphael said, hit us up at advocacy@freelancersunion.org if you have any issues or looking for any resources. We're very happy to help you and try to figure out what is available to you and just how you're protected. But now let's bring out our main guest for today's event, Meredith Ruff. Meredith is the Labor Standards Engagement Specialist with the City of Seattle Office of Labor Standards, which means she pretty much does all the outreach. She has a JD from the University of Washington School of Law, and prior to working for the city, she worked as an attorney for low-income Washingtonians at the Northwest Justice Project. So in her free time, she organized with prisoners around their rights. So who else better to have with us today? How are you, Meredith? How's it going?
I am doing pretty well, Jalen. Thank you so much. I'm really excited to be here and do some outreach on our freelancers, or we call it Independent Contractors Protection Ordinance. And yeah, just excited about the work that the office is doing to reach non-traditional workers and offer protections to people who haven't had protections before. Really excited. And I think I'm ready. Awesome. If you want to share my slides. Welcome to my slideshow, everyone. Thank you. I am really appreciative of the Freelancers Union for hosting us. I'm happy to be a part of this collaboration, and I'm here to talk to you today about our Independent Contractors Protection Ordinance, which is kind of a mouthful. Usually we call it the ICPO. It's also Seattle Municipal Code 14.34 if you really want to look it up yourself. Although I will say reading the law by itself, not that fun. So what am I going to talk about today? Let's show you. So I'm going to talk about what work is covered, because in order to get the protections of this law, there are some boxes that the work has to check. I'm going to talk about what your rights as freelancers, independent contractors are, what should happen when you're hired, what happens if there are violations, and then I will talk a little bit more about the Seattle Office of Labor Standards and what we do. All right, what work is covered? I tried to break it down. It can get a little complicated, but there are 4 main things that you have to check off to make sure that you are protected by the law. And the first one of those things is which type of workers are covered. So for us, that is self-employed, single person, independent contractors. You are not employed by another person or business. You're probably going to file Schedule C for your business and pay your business taxes. You have multiple customers. You're not financially dependent on a single person or entity. And you're a one-person shop, usually with an LLC or some sort of corporation. You are not covered if you have employees or business partners by this ordinance. So that's who do you have to be in order to get the protection. The next bit is who do you have to be working with in order to get these protections? The work that you're planning on doing has to be done for what we call a commercial hiring entity, quote unquote. What does that mean? This is a little bit of a circular definition, but a commercial hiring entity are entities that are regularly engaged in business or commercial activity. So if you're working for a business or if you were working for a nonprofit, also considered a business, those types of hiring entities are going to be covered. If you are working with a private household, that type of work is not covered by this ordinance. So one example of the differences between those 2 types of work, say a wedding planner hires you to design wedding invitations for a couple. That type of work would be covered because the wedding planner owns a business. That is part of their business. A couple who hires you to design wedding invitations would not be covered because they're not engaging in any sort of business or commercial activity. They just want these for their own private event. So that's kind of who you have to be doing the work for in order to get the protections under the ordinance. This is also one that we've had some questions on. So in order to be covered, all or part of the work that you're doing has to take place in the Seattle city limits. Outside of the Seattle city limits, the Office of Labor Standards, we don't have jurisdiction. We don't have power to kind of engage in disputes or help people out when the work takes place outside of Seattle. So we're going to get into this a little bit more, but if you are planning on doing part of the work in Seattle, particularly if that's not where your regular workspace is, that is something that you want to let the hiring entity know, because then they'll be on notice that they should be following the Seattle law. One of the questions we've gotten is, okay, but what if the business is in Seattle, but I don't work in Seattle? That's not covered. The work has to be done in Seattle. And it doesn't have to be all of it. Again, it can be part, but that is something that you should let people know if you want to receive these protections. The last bit about the work in order to be covered is that you have to expect to be paid at least $600 over the course of the calendar year. That means that either the proposed payment is $600 or that you reasonably expect that you will be paid at least $600 considering all of the work that you're going to do for that business or hiring entity during that calendar year. So if you don't know, but maybe a contractor has worked with them on a similar project in the past and that person has been paid more than $600 over the calendar year, that's a reasonable expectation that you are going to be paid that much. And so the work should then be covered by the ordinance. Those are all our little check boxes. So we are going to get into, if you fit this situation, what are your rights? And don't worry, I am going to break all of these down more, but this is just a snapshot of what your rights are. So whoever hires you, it is their obligation to do these things, to give these things to you. I will say this law in Seattle was passed in September 2022, so it just had its first birthday. A lot of businesses and hiring entities do not know that they are supposed to be doing this. That is something that we're working on. We want them to know. We want them to comply without you having to ask them to do that, but they might not know. So if you don't get these things from them upfront, you can always send them to our website and say, you need to comply with this, or you need to give me this information. But that's just an aside. What are your rights? So the hiring entity is supposed to give you something called a pre-work notice of rights before any of the work starts. That notice goes over a lot of the same information that I'm going to be giving you today. It's just supposed to outline your rights so that you know what they are before you start any work. It tells you that you are supposed to be protected from retaliation, which I'll talk about more later. And it should tell you how to file a complaint or a lawsuit if you have issues. The next thing that they're supposed to give you is something called a pre-work written notice. We also sometimes call it a pre-contract disclosure. That has information that is useful to you before you contractors start engaging in any work. The third right, and maybe one of the more important ones, is timely payment. So the law says that whatever hiring entity you're working with, once the work is complete, they have 30 days to pay you, or whatever you agreed to in a contract. So that could be beyond 30 days, like the contract can say whatever you two agree on, but if there is no mention of when you're supposed to be getting paid, it's 30 days after the work is completed. And the last thing, which also has to do with payment, is something called an itemized payment notice. That is a breakdown of how they're paying you, or what they're paying you for, what they're not paying you for. And we will really dive into that. And sorry, I forgot to mention this at the top, but my plan is to get through the presentation in case I'm answering questions kind of later down the line. If I don't answer your questions throughout the presentation, I'm going to look back at the comments when I'm done and try to get those questions answered. Well, you have me here. All right, so this pre-work written notice, like I said, that's what I'm calling it. That's what we really refer to it as, but it can also be called a pre-contract disclosure. The whole purpose of it is to give you information ahead of any contracting or agreement so that you can make an informed decision about whether or not you're going to engage in the work. Not all work requires a written contract, but having an actual written contract that both you and the hiring entity has signed can protect you from changes made to the work or any issues in the future. So I would say that that is a best practice, and the pre-work written notice alone is not a contract. It can be useful to hold people to kind of what they said, but it's not quite the same. So before you start the work, before you enter into a contract, the hiring entities are supposed to provide you with this written notice that includes your name and contact info, their name and contact info, a description of the work to be performed, which should be relatively detailed, a location of the work, your place of business, and their place of business, which can be useful later down the line when you're trying to figure out, how to deal with any issues. It should include payment information, like what are the terms and conditions of the payment? Is there a schedule? What do you have to complete before they pay you? Those types of things. It should contain the rate or rates of pay. Are they going to pay you per hour? Are they paying you per project? Are they paying you a piece rate per item completed? Is there some sort of commission? What's the breakdown? Those things should all be covered in this written notice. It should also talk about tips or service charges. And if you are going to get any of those, I would say that comes up a lot for people who do kind of food service, chefs, caterers, bartenders. If there's any sort of tip or service charge, there should be a breakdown on who's getting what in this written notice. Should talk about any deductions, fees, or other charges that they want to or that they are going to subtract from your payment. And it should also talk about what expenses are they paying for, what expenses are they reimbursing you for. The payment schedule, which I talked about. But a date. It can't just say to be determined. Same thing with rates or rates of pay. It can't just say to be determined. It has to be clear about how much and when you can expect to be paid. The notice should be provided in English. And if English is not your primary language, it also should be provided in your primary language so that everybody is on the same page and has the same access to what that information is. One of the reasons I think having a contract is useful is that the law does allow hiring entities to make changes to this pre-work written notice. So they can change items on this. If they change more than 6 of the items, they're supposed to give you a whole new pre-work written notice instead of kind of doing it piecemeal. Like, say they've been emailing you about 5 changes they want to make. They make 6 changes. They just have to give you a whole new document. And that is one of the things that makes this very different than a contract, because if you have a contract with somebody, no one can make unilateral changes to it. Both parties have to agree on any changes made. So a contract can kind of prevent somebody from making those changes to the work that you're planning on doing. We do have a sample of one of these notices available, and you'll see a QR code later in the presentation. I think there should be a ticker kind of rolling by with different websites. That's on our independent contractors protection page, but again, the QR code will be up so that you can just scan and take you right there. All right, talked about before the work happens, this is what they're supposed to give you. Once the work has been completed, or you're getting paid for the first time, maybe you're getting paid multiple times, every time the hiring entity pays you, they are supposed to give you something called an itemized payment notice. And that should contain a lot of the same information, but more specific to payment. So it should have the dates, description and location of the services or the work, your information and their information, the pay basis, again, like we talked about, including tips or service charge distribution, if that's applicable, whatever the gross payment would be, any deductions that they make that are agreed upon or that were in the pre-work notice. They can't just slam you with deductions if there were no deductions kind of in that pre-work notice or in the contract. And then what is the net payment after they're deducting? It should also contain information about the expenses that they're reimbursing. And like all of our notices, it should be provided in English and also your primary language if that is not English. All right. Talked about the notices, but as I said, not all hiring entities know that they are supposed to be doing this. And even if they do know, that doesn't mean that they necessarily are going to do it. I think probably many of you have had experiences with hiring entities that don't want to give you everything that you're owed. So what happens if they don't give you those notices? Basically, if they don't provide you the notice, that kind of gives you a one-up in a court or investigation situation. If you do end up filing a court case or a complaint with the city and there's an investigation, the court or the city should take what you say the agreement was as the truth. So they don't give you any notices, that record doesn't exist. You say, this is what we agreed on. The court or the city should believe you first. The way that the hiring entity can kind of get out from under that is that they have to show something called clear and convincing evidence that there's some other agreement. The clear and convincing evidence standard, I'll just let you know, is not super clear. There's no like bright line rule for what is clear and convincing and what's not. I would say it's less than beyond a reasonable doubt, which is our criminal standard that you all have probably heard of. But it's like more than 51%. So that's too low. Beyond a reasonable doubt is too high. Clear and convincing is somewhere in between that. An example of clear and convincing evidence could be a contract that you did sign or other written agreement, for example, in an email or a text message that shows that, you know, what they're saying is the truth, but it cannot just be them saying that you're lying and that you're wrong in that situation. So that's what happens if they don't give you the notices. You kind of get that one-up situation until they can prove otherwise. And like I talked about, Here's the QR code. I mentioned if you scan that, that will go to the resource page for independent contractors. That page contains a model pre-work written notice, a pre-contract disclosure, an itemized payment notice, and the notice of rights that they are supposed to be giving you when you start working together. So I think there are a lot of different uses for them. We did create them so that hiring entities wouldn't have to make their own, but I think you all can also use these either upfront with hiring entities to get the information that you want, because that information is useful to you when deciding if you're going to contract with somebody or pursue work with them. And you can also just use it to have in your back pocket to see if a hiring entity is providing you with all of the information that they're supposed to. And one thing I'll mention is, yes, we have these model notices, super nice when businesses use them. They don't have to use these exact model notices. They just need to provide you with the same information. So if they use a different form or a different document, that is okay for them to do, but you can use the model notices to kind of cross-check and see if they are actually providing you with all of the information that's required. Those are our model notices. Then we're going to get into violations. So I think non-payment is probably one of the top violations. And there are two different things that you can do if a hiring entity violates the law, either by not paying you at the correct time, shorting you. We'll also talk about retaliation if they violate the law in that way. And the first one of those things is to file a complaint with our office. So I think, like Raphael was saying before, even if you had a contract, the only thing that you could do was go to small claims court. I'm still going to talk about small claims court because that is one of the avenues available to you. But now that we have this ordinance, you can also file a complaint with our office. There are different ways to do that. You can call or go online. I know Jalen put the complaint form in the chat. It's also rolling across the screen. You can also scan that QR code. And then I will have our phone number at the end of the presentation, so you can call that phone number. You can also just show up to our office. It is open to the public. It's in downtown Seattle, and the address will be on the last slide. So if you want to come in and talk to somebody, you can. I think going online or calling is much easier and won't leave you waiting in our beautiful entryway for somebody who is available to talk to you. So what happens when you contact our office? One of the things that I like about the Office of Labor Standards that's different from other labor agencies, for example, like Washington's Labor and Industries, is that when you contact our office, you can remain anonymous when we're talking to anybody outside of the office, and you can just ask for that. You can say, I want to remain anonymous. I don't want to be named throughout this process. So that is something that you can ask for. OLS, probably somebody from our enforcement team, because that's who takes our worker complaints, will talk to you about the problem. They'll try to collect important papers like any contracts, any notices or communications between you and the hiring entity. Excuse me. They might have some follow-up questions for you, although I will say our complaint form asks a lot of questions. Sometimes they still want more information. So they might have follow-up questions for you. And after reviewing all of that information, OLS, or the Office of Labor Standards, will decide how we can help you. And that could be by investigating the complaint, referring you to one of our community partners who's working on the Independent Contractors Protection Ordinance, or other agencies that might be able to help you with your claim. I think that last one, other agencies, is especially true. You all might not experience this a lot being freelancers who are pretty clearly independent contractors, but a lot of the time businesses hire quote unquote independent contractors. Really, they should be treated as employees. They're misclassified. And so that is something that somebody like Labor and Industries would look into. So we might refer you to other agencies. And then something that we do for every complaint that comes in the door is that we, as the Office of Labor Standards, send the hiring entity or the business a letter asking them to comply with the ordinance, and that tells them to call kind of our employer enforcement liaison so that she can walk them through exactly what they're supposed to be doing and why they're not in compliance. And again, your name can be left out of that if you want to remain anonymous. So they will not necessarily know who is making the complaint. I really wish that we could investigate every single complaint because that's what I want. I want businesses to kind of fall in line and do what they're supposed to be doing. But because of the number of complaints that our office gets, we can't investigate all of them. And investigations take anywhere between like 6 months and 18 months. So we have quite a number going on and they're time consuming. So we can't investigate all of them. And we do have a way of prioritizing cases. You can find that information on our website. But I think making a complaint can still get you some answers about what your rights are. If you want clarification, our enforcement team can answer those questions. And I have found that sometimes a letter from an agency goes a long way into getting a hiring entity to comply or to pay up. So it can be useful just to get that letter. And they're very serious letters. My coworker who writes them is great at her job. Okay, that's what the Office of Labor Standards can do. What can you kind of do on your own? This was already available to you, but because of the law, you now have some more protections that you can point to in small claims court to say, this is what needed to happen. It didn't happen. And I'm going to just dive into it a little bit because I used to do this kind of work when I was an attorney. So the other thing that you can do is go to small claims court, which we talked about, if your claim is less than $10,000. If it's more than $10,000, you have to go to regular district court, which is kind of a pain. I would say the benefits of small claims court is that nobody gets an attorney. So there are no attorneys welcome in small claims. And it's just less expensive than other types of court filings. It's less expensive. It's less time consuming. Doesn't mean it's not time consuming. But you just don't have to do as many things in order to get in front of a judge. How would you go about doing that? I know we have the QR code to the small claims court guide from Washington Law Help, also a great place to get a lot of different legal information. But the first thing that you do is file a claim in the district court area where the hiring entity does business. And that figuring out that district court area is really important because if you don't file it in the right place, they will just tell you, you did not file this in the right place. You have to go somewhere else, which is not super fun and kind of a pain. So how do you know what district they do business in? They have an office in a certain district and they should have provided you that information on some of these notices. That is the easiest way to know where you're supposed to sue them. And it's also the easiest district to sue them in because of how our laws work and where the law says, you know, this court has the power to talk about this issue that these people are having and make decisions about it. If you don't have their address and you want to find out, I'm just going to drop this in the chat. You can go to the Secretary of State website and do a business lookup. No, I actually don't think I could join the chat, but I'll just tell you what it is and then we can send it out afterwards. It's apps.apps.sos.wa.gov/corpse, CORPS. I know it said core, but I'm going to say corpse. And then another backslash. So that's a business lookup. That's what I use when I'm trying to find businesses, where they're located, who their agents are. So if they didn't provide you with that information, you can do that. You can also call the court clerks and ask them if a particular address is within their district. They'll tell you that information. You can't just base it on what county the address is in because most counties have more than one district court. For example, Snohomish County has 4 district courts, so you really do have to know which area you're supposed to be going. And then if they are an out-of-state business, but they're working with you, you're in Seattle, that means that the law applies to them. Then you can kind of figure out which district they're transacting business in. which is a legal term, transacting business. What does that mean? But if they're contracting with you, they're working on something with you, that's likely a business transaction. And you can argue that that district should work because they are doing business there, even if their office is located somewhere else. That doesn't work as well if their office is located somewhere else in Washington, but out of state. I think it works better. You can still try if it's somewhere else in Washington and say they're transacting business here. This should be the district where I can get this heard. And just a little caveat, I can't give you legal advice. So like if you want to get deeper into this, I would definitely suggest checking out that guide or asking an attorney for actual legal advice where you have a relationship and you have the confidentiality and all of those things that an attorney can give. And I did send Jalen some resources, free resources that are available to folks in Seattle and King County, including specifically artists where you can get legal advice. Okay, we talked about filing the claim. You got to file the claim in the right district area. The claim is something called a notice of claim. Every county has its own notice of claim because Washington state courts are all different depending on what county they're in, and they all have their own documents. So you want the right notice of claim in the correct county, in the correct district. Then you serve the hiring entity with that claim. I find it easiest to just do that by certified mail or registered mail, return receipt. That is fine. That's also one of the reasons the small claims court is a little easier. You do not have to have somebody personally served, or, you don't have to pay somebody else or have a real live person go up to them and give them the documents. You can mail them. And you should be sending that to their registered or managing agent. That either should be in those notices, but if they didn't give them to you, then that information is also typically available on the Washington Secretary of State's website or another state's business directory. That's usually part of what they have to give in order to become licensed. Okay, so you filed, you served. In some courts, there's an option to participate in mediation. I know that that's very true in King County. Mediation can be useful. Courts usually want you to do it because they want to cut down on the number of cases that actually get in front of the judges. So they want you to try to come up with some way of kind of neutralizing whatever the issue is or compromising before you get in front of the judge. You're not just meeting with the hiring entity alone. There's a mediator there. That person's job is to help both of you come to an agreement, but they definitely don't take sides, and they will not advocate for anything specific, those mediators. If mediation doesn't work out because you can't come to an agreement or the other party refuses or you just don't want to do it, then what you do in small claims court is you go to a court hearing or a mini trial with your evidence. So to do that, what I typically tell people is that you want to prepare a trial binder, which just means 3 binders, 3 1-inch, 3 ring binders, with 3 copies of all of the evidence that you want to use. One is for you, one is for the judge, one is for the other party, just so that everybody has the same information and can look it over. And then you would, if you file the claim, that means that you are the petitioner or the plaintiff, and you would get to go first. So you would lay out your argument, like the agreement was for me to pay this amount at this time, and the hiring entity did not do this. There's no record of payment. That's kind of the argument. In terms of just protecting yourself throughout these experiences, like while you're getting work, I would say, you might already know this, but try to get everything in writing, because writing is better evidence than just saying, well, this person told me this. You can say that when it's like the other person in the courtroom because they're right there and they can give their side of the story, but it's not as convincing as something that's in writing. If a hiring entity only wants to talk to you in person or over the phone, they don't want to do anything writing, I would say, 1, that's a red flag. And 2, something that you can do to kind of protect yourself in those situations is send an email or a text message or some kind of written document after those conversations, stating like what your recollection and understanding of the conversation was. And if they don't respond back by saying, no, that's not what we talked about this, or if they just don't respond at all, it's easier to say like, look, I sent them this message. This is what I said my understanding was. They didn't say anything back to me. So I thought that there, was agreement on that. Yeah, protect yourself, get things in writing, if at all you can. Okay. So we talked about the two different things that you can do, aside from just like working with community-based organizations and getting them to try to help you talk to these people. I think that's another option, but these are kind of the two main roads of what do you do if whoever hired you is violating the law. Now we're gonna just get into retaliation a little bit. So what is retaliation? It's something that you are supposed to be protected against, but not everybody really knows what it means. Basically, retaliation is when a hiring entity takes negative action or adverse action or discriminates against you for asserting your rights. You have to assert your rights in good faith. That's what the law says. All that really means is that you really think that like these are your rights or that there's been a violation. And even if you're wrong, it doesn't matter. That's not what good faith means. It just means that you're not like making this up to harm somebody or to mess them up. You legitimately think that you have a claim or that what you're saying is correct. So if they take negative action against you for asserting those rights, that's what retaliation is. And some examples of like, what does it mean to exercise your rights? So what is protected by this law? It means you can ask about your rights under any ordinances. It means you can tell the hiring entity, a union or legal counsel about alleged violations. It means you can file a complaint. It means that you can participate in an investigation or file a court case. And it also means that you can inform other workers of their rights under the ordinances. So all of those actions are protected. What does negative action mean? What can hiring entities not do? They can't deny or limit your access to work. They can't offer you less desirable work. They can't terminate your relationship. They can't deactivate your account if you use an account or some sort of app to get work. And they also can't leave bad reviews. I think the difficult part about retaliation is that those negative actions have to be done in response to you, like advocating for your rights. So a lot of those things are actually legal for them to do as long as they're not doing it in retaliation for you exercising your rights. If they just say, I don't want to work with you anymore, but it's not in response to you exercising your rights, I would not call that retaliation. So what's an example of this that I came up with? We have Alonzo. He hires a plumber, Jaime, to fix the plumbing at the Airbnb that Alonzo rents out as part of his short-term rental business. So we got the business entity covered. This is not a private household. It's covered by the ordinance. They did not agree on a specific timeline or date that payment would be made. 30 days after Jaime finishes the job, Alonzo still has not paid him. Jaime calls Alonzo and threatens to take him to court because he hasn't been paid. Alonzo laughs this off and starts leaving bad reviews about Jaime's independent contractor business online. So here you can kind of see Jaime is advocating for his rights. He's saying, I'm going to file a court case. In response to that, Alonzo takes negative action against him. That is an example of retaliation. And then lastly, this is my last slide, then I can get into questions for a bit. This is our contact information. So that's our address, our phone number, and then that is just our basic website, not the one that's specific to, or not the page that's specific to independent contractors. But if you do other types of work, you will find a lot of useful information there. And a little bit more about the Office of Labor Standards. As a whole, we write policy on labor laws, rules for how to enact these laws, which are passed by the City Council, signed in by the mayor. We do outreach and education, which is what I'm doing right now. And we work with a lot of nonprofits in the Seattle area because they do a lot of great outreach work. And we investigate complaints. So we have these three kinds of teams, and we all do different things. Enforcement would be the investigator. So if you do file a complaint, that's the team that you would end up talking to. We oversee all of the Seattle labor laws, most of which cover people who are employees, like the minimum wage and paid sick and safe time, rather than independent contractors and gig workers. But we are working on kind of broadening coverage, making sure that people know their rights, and the city council has passed more non-traditional protections for non-traditional workers. And then, like I said, there's a lot of resources listed on the website specific to independent contractors. I can page back to that QR code just so that it's up if you all want to look at all of them. But what we have available is the ordinance itself, which can be hard to get through, a fact sheet, which is just kind of more condensed information, something called a Q&A, which our policy team writes. And that goes pretty in depth, answers a lot of questions because they're trying to identify like any questions that people might have about this. And then the notice of rights, the pre-work notice, and then the model itemized payment. So yeah, I'm gonna try to go through the chat and answer the questions that folks have. But if I can't answer them off the top of my head, because I might not know the like little minuscule ins and outs that somebody from policy or enforcement might know, then I can answer those questions later. And I can't join the chat because I'm not logged into YouTube. But
I can read it for you if you like.
I can see the questions. If you all want to contact me, I would actually probably just go to the complaint form, but you're welcome to contact me. And my email is just meredith.ruff@seattle.gov. Okay, I'm gonna page back to this QR code in case folks want to look at it. And if I am looking away, it is because I have a lot of resources up on my other screen to help me answer some of these questions. Yeah, thank you, Jalen, for putting that in the chat. Okay. Actually, if you guys want to scan that, I can definitely send the slides out later. I know that this will exist in perpetuity on YouTube, so I might just stop sharing so that I can have a little more screen room. Oh, that works too. Okay.
And would you like me to go through some of the questions?
Yeah, if you want to read them out, that would be great.
Sure. So the first one is, if you could clarify, what does it mean that the work needs to be done all or in part of in Seattle? I operate my business in Shoreline, 200 meters north of Seattle city limits, but I'm frequently doing client work within Seattle city limits.
Yeah, so I would say that if you are doing client work in Seattle city limits, if you are taking meetings, if you are working on any piece of the project, you're talking to people, you're doing any of what you need to do in order to complete the work that you agreed on in the Seattle city limits, I would say that that's covered, but the hiring entity has to either know outright or should know that you are doing part of the work in Seattle in order for you to be covered. Because if they have no way of knowing that, they can argue like, well, we shouldn't be subject to this law because we didn't know that any of this was happening in Seattle. And maybe it's a little easier if you're in Shoreline because you are right there and you can just say, like, you know that I'm coming into Seattle, but that is something that you would want to make super clear up top that you are going to be doing part of the work in Seattle. Let me see if I can just get any more specific.
And I think you can correct me if I'm wrong, because I do know how we have in New York where the law is written loosely, where at least one party has to be located in New York City. But you can have it stated in the contract for a clause of governing law that it would fall under the jurisdiction of New York City, just so there's no ambiguity or anything like that, especially if you are in New York and your client's somewhere else or anything like that. Do you think something like that could work for this case, for the Seattle ordinance?
Yeah, I mean, usually I do, and I'm looking through the Q&A again. This is like our document that has the most like clear answers to questions, and it just straightforwardly says, when does a hiring entity know or have reason to know that the work is being performed in Seattle? When does the law apply? And it says the independent contractor provides them with information that the work will be performed in Seattle in whole or in part, or the independent contractor provides services that in fact include a work-related or commercial stop in Seattle. So if you're doing business in Seattle, even if your office is not in Seattle, that counts. You just have to put them on notice.
Got it. Cool. All right, we're going to move to the next question. What kinds of monetary damages are we entitled to with things of like late pay or clients who employ retaliation? And for example, like with here for the freelancers for New York City, freelancers are entitled to double damages for late payments and legal fees.
That is such a good question, and I actually don't know the answer off the top of my head, but I will just see if I can find it super quick.
And if not, we can always, I mean,
we'll
use this as,
I know that's really important to y'all, obviously, because it talks about like, you know, how much should you be getting paid? Yeah, I don't want to talk and not give you the right information. So I'm going to hold off because what I really want to do is search the ordinance. And that is a little bit more painstaking, but.
No problem. So for now, we'll go to the next question. Can you explain what compromise would come from mediation? Would that be like a payment schedule or reduction in amounts of fees due?
Yeah, so mediation, there are no rules. There are no rules on what you can agree on. And so it's just like, what would you be willing to go for? I can see situations where maybe what's more important to you is getting payment now rather than like maybe getting partial payment now rather than getting what you fully agreed on later. I can also understand why you would not want to make that compromise because you are owed a specific amount of money and you want that full amount of money. But it could also look like a payment schedule that you agree on. And then if they default on that payment schedule, you could go back, things like that. So that is usually what I would say compromise ends up being. But one of the best parts of mediation is that you can walk away and just take it further. And then I will say a lot of what well, actually, let me go back. Mediation, if you sign a mediation agreement, that is what they will expect you to keep to. You would not then be able to go back and say, I do actually want to sue you for the whole amount. So if you sign that agreement, that's an agreement, and that's something that you should think about. A lot of the time, if you file a complaint and it's investigated, what happens to end that investigation is that the business might settle with the city of Seattle, and those settlement agreements can have similar compromises, payment plans, things like that. But usually what the city is working on is getting what you are fully entitled to, with just not having to go through the, like all the way top to it's called a hearing examiner. It's kind of like an administrative law judge. That's what happens when you have an investigation that goes all the way and doesn't get settled. So kind of similar, but a settlement agreement prevents that from happening.
Got it. Cool. All right. The next question is, thank you for the presentation. Can several independent contractors being hired by an entity, for example, freelance artists on a commercial video project for a company, exercise these rights together?
I do not think that the law is, I mean, I think you can exercise the rights together. Oh, could you become joint plaintiffs? That's actually a more complicated legal
question. Sounds like a class action lawsuit almost, maybe.
It's possible. Usually a class is like pretty big. Yeah. There's nothing that says you all can't work together to try to get something done. And I will say, if there are multiple violations happening from the same business, that is something that makes our office more interested in getting involved, because it doesn't just affect one person, and like a settlement wouldn't just affect one person. I think, especially if you go to small claims court, it would be very complicated to have multiple plaintiffs. But that does not mean that in banding together and, all filing suit or all filing complaint, that wouldn't provide more leverage. So not really a full answer, but I guess it's more of a no on paper, yes in real life. Yes, practically you can work together. On paper, you probably would have a difficult time all being together and getting this, or getting all the same, outcome for each of you.
All right. The next question is, are there any lawyers who can write demand letters for us pro bono? Is there anything you can recommend? In my experience, going to small claims court takes too long and we need to get paid ASAP.
Yeah. So, that's one of the reasons filing a complaint, it will get you a letter, not as specific as a demand letter might be. And then I did send Jalen a couple links via email before we started for some free legal services in King County. One of those is Washington Lawyers for the Arts. They have a clinic that's open once a month. And then King County Bar Association neighborhood legal clinics, I think, are also a good one to use. Washington Lawyers for the Arts, I think they'll do outside King County. If you want to go to a King County neighborhood legal clinic, you either have to live in King County or the problem has to be taking place in King County.
Got it. All right, cool. All right, I think we have just two more. I don't know if it's one more question that might be a two-parter, but this question is, if all of the information required in the pre-work written notice is covered in a written contract already, then does that cover the spirit of the law? And the second part is the hiring entity required to provide the itemized payment notice before they issue payment or as a record of payment? So let's tackle the first half first.
Yeah, and this is a great question. I was planning on talking about that, but didn't end up doing it. So thank you to whoever asked that. They don't have to use the model notices. They can, that's why we made them, to make it easier, but they don't have to. All they have to give you is a written document with all of that information on it. So if all of that information, it honestly shouldn't be covered in a contract, because the whole point of doing this is that you get the information before you enter into a contract. But I think there's an argument to say an unsigned contract with all of that information is the same thing. It puts you on notice. And so I think a contract could stand in for a pre-work notice.
Got it.
And I, just a second, Jalen, I did actually find the answer to the previous question about payment, and you can get, we call it liquidated damages, up to twice the amount of the unpaid compensation. So you can do that. There can be further penalties payable to you or payable to the city, depending on what the situation is. So yes, that is one of the remedies that you can get under this law.
Got it. Cool. And then I guess the second half is the hiring entity required? Yeah, to provide itemized payment notice before they issue payment or as a record of payment.
So they're required to do it when you are paid. So it doesn't have to be before payment. It can be part of the payment record. It can be before payment, but because they have to do it at each time you're paid, I would guess it's more like a pay stub. And it comes with the payment.
Yeah, and then generally you can have a payment schedule predetermined, and then pretty much you can have different clauses for like late fees or anything like that if the client doesn't fall within those dates. So that's another thing you can also have.
Do in a contract, yeah, totally.
Okay, and just one final comment regarding the Washington Lawyer for the Arts. It was not free. at least not 5 years ago, but I felt paying a small fee to get contract negotiation help. That's usually how those organizations are. They usually have just like a one-time either yearly fee, and you get help as much as you need, depending on what the issue is. I know here for volunteer lawyers for the arts in New York City, it's just one yearly fee of like, I think $170. And then they also offer like senior citizen discounts, student discounts, things like that. But it is a lot cheaper than hiring the lawyer outright. So completely pro bono, that might be a little bit harder. Unless you have friends or family who are willing to do it pro bono, but there's sometimes other like legal clinics. I know like for the Washington Lawyer for the Arts, they have like a legal clinic, as do we in New York City. You just have to check out some organizations like that might be able to do things pro bono in that sort of sense.
Yeah, that is really good to know. And I am actually really interested in finding out if their clinics at least are free, if not a demand letter. King County Bar Association neighborhood legal clinics are free. We also have, if you're in the LGBTQ plus community, there is the Q Law clinic. I think, yeah, it's just called Q Law. But they can do similar things. They probably would not write you a demand letter, but they can at least give you legal advice, or maybe ghostwrite some sort of demand letter. Yeah.
Cool. Well, that's pretty much it for the questions, and we are pretty much at time as well. So that was pretty good. Thank you so much, Meredith, for taking time out of your day to help inform some of just kind of the whole process of everything, if they're dealing with non-payment, and what rights they have and how they're protected in Seattle. But yeah, it was very informative. We hope everyone enjoyed. I will email everyone who originally signed up for this event all the extra links that Meredith has provided, and also update everything down below in the YouTube description, with all those links as well. So if you check back here later today or tomorrow, you should see all those extra links. Definitely check out those resources, definitely educate yourself, definitely let other freelancers know as well. That's also the biggest thing that I find is an issue, where other freelancers may not know how they're protected, and we're pretty much only as strong as our whole community and helping each other out in that sense. But yeah, Meredith, you want to I'll throw up your presentation one more time just for that last slide, if anyone wants the contact just again before we end. There you go. So if you do have any questions, feel free either call or email. I did put Meredith's email in the chat as well earlier. But yeah, thank you all so much for joining us today on this wonderful event. Be sure to like this video, subscribe to our channel for other updates and other workshops and panel talks and things like that. And also sign up for our newsletter as well. And be sure to follow us on social media at FreelancersU and at NYC_hub for the hub and all of our programming. Thank you again, Meredith, so much for taking time of your day. We hope you have a wonderful day. Yeah, take care.
Yeah, thank you all so much for having me. Everyone have a great day.